Shocking! She walked into that courtroom, looked the jury dead in the eyes, and said she never saw anything. But 3 years earlier, handcuffed to a chair, police screaming obscenities in her face, threatening to take her 3 children away forever, she had signed a 4-page statement naming the killer. And here's the part that should make your blood run cold. The prosecutor knew she was going to say that. The defense attorney knew she was going to say that. Even the judge knew. And they called her to the stand anyway. So you have to ask yourself, if everyone in that courtroom already knew this witness was going to recant, why was she there at all? The answer to that question sent a man to prison for life. And it may have broken the law in the process. Before we go any further, I need you to know that videos like this one take serious time. I'm talking court transcripts, appellate opinions, post-conviction hearing records, police interview summaries. Hours and hours of reading just to give you the full picture that no one else is telling. If you believe that real cases deserve real research, not clickbait summaries, not half-truths, then hit that subscribe button right now and turn on notifications. It genuinely helps this channel keep doing exactly this kind of work. And it means everything. Now, let's get into it. This is the case of Heath Bell, a man convicted of first-degree murder in Memphis, Tennessee, and sentenced to life in prison. On the surface, it looks like a fairly straightforward conviction. 2 witnesses spotted 2 men with guns acting suspiciously near the scene. Cell phone records placed the defendant in the area. A ballistics report confirmed 2 weapons were fired. But there is one piece of evidence that stands above everything else. One statement. 4 pages. Signed at 6:52 in the evening on February 18, 2013, by a woman named Chamere Talley. That statement described seeing Heath Bell, a man she said she had been dating, running from the direction of a rolling truck immediately after gunshots rang out through the Pendleton Place apartments in Memphis. Without that statement, this case is largely circumstantial. With it, Heath Bell goes to prison for the rest of his life. But here's what I'm going to show you today. The circumstances under which that statement was obtained. The moment a defense attorney admitted, out loud, under oath, that he knew he should have fought it and didn't. The legal trap hidden inside a courtroom ruling that almost nobody talked about. And a question that still doesn't have a clean answer. Was justice served here, or was justice bypassed? Remember, it is better to let a suspect go free than convict the innocent. Stay with me. Because this case gets more complicated every single time you look closer. Memphis, Tennessee. February 2013. Joe Howell was a regular guy. He had recently leased a brand new Hyundai, a small luxury, the kind of thing that feels like a fresh start. On the night of February 15th, he drove a woman to her sister's apartment at the Pendleton Place apartments. He dropped her off. And then, according to witnesses, he went around the corner to sell someone some pills. He had $1,500 in cash on him that night. He never made it back. He was found shot to death inside his vehicle, money gone, no eyewitnesses to the shooting itself, the car still rolling when neighbors began to emerge from their apartments to see what had happened. Now think about what the Pendleton Place apartments looked like that night. It's late. It's cold. Families are inside. Children are on the floor being shielded by their parents because gunshots just tore through the air. People are afraid to look out of their windows. And in one of those apartments, a young woman named Chamere Talley was at home with her mother, her 9-year-old son, her nephew, and her sister, the same sister who had just been dropped off by Joe Howell minutes before the shooting. Chamere was a neighbor of Heath Bell. She knew him. She knew his face, his nickname, his cap. She was, by some accounts, romantically involved with him. She was also, on the night of February 15, 2013, someone who knew something. And that knowledge was about to destroy multiple lives simultaneously. This isn't a story that begins with monsters. It begins with ordinary people, a man with cash and a new car, a woman at home with her kids, a neighborhood where everybody knows everybody. The kind of place where you recognize someone's cap from across a parking lot at night. And that recognition, that single, ordinary moment of familiarity, is what this entire case ultimately hangs on. Here's where things stop making sense. 3 days after the shooting, detectives brought Chamere Talley in for a formal interview. They said she came voluntarily, she wasn't in custody when the interview began. But within a short time, they handcuffed her ankle to the chair she was sitting in. She said they screamed at her, called her a liar, told her they were going to take her 3 children, aged 14, 9, and 3, and separate them. She said they printed out a first-degree murder form and took her thumbprint as though she was being charged. She signed the statement. Now, here's the problem that nobody could cleanly resolve. 3 days later, at a preliminary hearing, Chamere Talley sat down and said the opposite of everything in that statement. She said she never saw Heath Bell. She said the police told her what to say. She said the entire statement was fabricated under duress. And the result of the preliminary hearing? No probable cause. Heath Bell was initially released. But then the grand jury indicted him anyway. And Chamere Talley, the star witness who had already publicly recanted her statement, disappeared. A material witness warrant had to be issued to bring her to trial 2 years later. So here is the question you should be sitting with right now. If the prosecution's most important witness had already told the judge that her statement was coerced, why was that statement allowed to walk into a courtroom and convict a man of first-degree murder? The answer is buried in a legal rule that most people have never heard of. Let's go back to February 18, 2013. Detectives from the Memphis Police Department's Homicide Bureau brought Chamere Talley in for questioning. According to Detective Frias, she wasn't under arrest when the interview started. She even voluntarily handed over her phone. But then something shifted. When Detective Frias scrolled through that phone and found Heath Bell's number, a man Chamere had just told him she didn't know, she broke down. Started crying. Said repeatedly that she didn't want to die. Said she was afraid for her children. That's when she was restrained. Ankle cuffed to the chair. What followed was nearly 3 hours between the signing of her rights waiver at 3:59 p.m. and the signing of her completed statement at 6:52 p.m. In those 3 hours, detectives verified pieces of information she provided before moving on. They gave her water. They left. They came back. Detective Frias admitted, under cross-examination, that he and his partner may have screamed obscenities at her. He admitted he told her she could be locked up for giving a false statement. He admitted he asked her, and think about this line carefully, who would care for her children if she went to jail. He denied threatening to take her children. But he acknowledged asking about them. When that statement came out, it named Heath Bell. It described him as a man she'd been dating for 2 months. It placed him running from the direction of the victim's truck, recognizable by the side of his face and the cap he always wore, immediately after the gunshots. 4 pages. Initialed on every page. Signed at the bottom. But the woman who signed it would spend the next 2 years trying to take it back. Weeks later, Chamere Talley sat in front of a judge and said what she had apparently been wanting to say since the moment she walked out of that police interview room. She said the statement was not true. She said she told them over and over again that she didn't know what happened. She said they called her a liar. She quoted the detective, and she used his exact language in open court, telling her it didn't matter, that he was going to go get her kids and separate them. And then she said something remarkable. She said that in the middle of the interrogation, she asked for an attorney. And the detective told her, "What do you need an attorney for? You're not being charged." The judge at the preliminary hearing heard all of this. And the result was a finding of no probable cause. Heath Bell walked out. But the story wasn't over. Not even close. The grand jury saw the same evidence, including those phone records showing repeated calls between Bell, his co-defendant, and both Talley's sisters in the hours before and after the shooting, and they indicted him anyway. The state's theory was crystallizing into something more calculated, that Chamere Talley had tipped Bell off that the victim was carrying cash and knew where he'd be that night. That this wasn't just a random robbery, it was a setup. And the woman at the center of all of it was now nowhere to be found. When Heath Bell's trial finally came, the prosecution faced a problem everyone already knew about. Their key witness didn't want to testify. Chamere Talley had been declared a material witness. A warrant had been issued for her failure to cooperate. She had been arrested and released with the understanding that she would show up to court. The prosecutor admitted under oath, at the post-conviction hearing years later, that he called her to the stand without even speaking to her beforehand. He said, "I would call her to the stand without talking to her because I didn't know what she was going to say." Let that land for a second. He knew she had recanted. He knew she had been under a material witness warrant. He knew she had refused to cooperate. And he called her anyway. Because here's the legal mechanism that made it all possible. Tennessee Rule of Evidence 803-26 allows a prior inconsistent statement to be admitted not just to challenge a witness's credibility, but as substantive evidence, meaning the jury can treat it as actual proof of what happened, not just as evidence that the witness is unreliable. Under this rule, the statement Chamere Talley gave to police, the coerced one, the one she'd been trying to retract for 2 years, could be placed before the jury as direct evidence of Heath Bell's guilt. All the prosecution needed to do was put Chamere on the stand, watch her recant, and then introduce her prior statement under 803-26. And that's exactly what they did. Now here is the moment that defines this entire case. Heath Bell's trial attorney, a retained lawyer, not a public defender, testified at the post-conviction hearing. And what he said is, frankly, extraordinary. He confirmed that he knew Chamere Talley's statement was crucial and devastating to his client's case. He confirmed he was familiar with Rule 803-26, which required a trustworthiness hearing before such a statement could be admitted as substantive evidence. He confirmed the trial judge had asked him whether he objected, whether he wanted a hearing. And he said no. He said he didn't object. His reasoning? He believed the jury wouldn't be able to distinguish between substantive evidence and impeachment evidence anyway. He thought the statement was coming in regardless, that the co-defendant's attorneys would have introduced it themselves, since the statement described the second perpetrator as having dreadlocks, and the co-defendant didn't have dreadlocks, making it actually exculpatory for the co-defendant. He said he wanted the full statement in front of the jury to show the coercive circumstances under which it was obtained. But then, and this is the part that has stayed with me, he said this, almost word for word. "I understand that I should have asked for a hearing. I should have objected. I regret not creating a record. I do believe that was an error. But in hindsight, I would have done it differently." He said that. Under oath. About his own performance at trial. The question is whether saying it years later, in a post-conviction hearing, means anything at all for the man serving a life sentence. Heath Bell filed for post-conviction relief. His new attorneys argued that both his trial counsel and his appellate counsel had failed him, that the failure to challenge the admission of Chamere Talley's statement under Rule 803-26 constituted ineffective assistance of counsel. The post-conviction court denied relief. Bell appealed to the Tennessee Court of Criminal Appeals. The appellate court's opinion, filed in April 2026, went through each argument methodically. On the trial counsel issue, the court found that while trial counsel may have made a mistake in hindsight, his decision not to object was, at the time, a strategic choice. He had reviewed the law. He had discussed it with his client. He had reasons, even if those reasons turned out to be wrong. Under the legal standard established by Strickland and Washington, a defendant must show not only that counsel's performance was deficient, but that the outcome would have been different if counsel had performed correctly. And here's where the court drew its hardest line. Even if trial counsel had demanded a hearing under 803-26, the trial judge had already made clear, at the motion for a new trial, that he found the statement trustworthy. The same detective who would have testified at a pretrial hearing did testify at trial. The jury heard everything about the recantation and convicted Bell anyway. The court concluded. No prejudice. No relief. On the appellate counsel issue, the court reached the same conclusion. Appellate counsel had reviewed the record and made a judgment call that there were stronger issues to raise. The court found that judgment reasonable under the circumstances. Heath Bell's appeal was denied. His life sentence stands. Okay, I want to stop here for a moment and ask you something directly. Because at this point in the story, you have a defense attorney who admitted under oath that he should have objected. You have a prosecutor who called a witness he knew was going to recant. You have a statement obtained while a woman was handcuffed to a chair, threatened with losing her children, denied her request for a lawyer. And you have an appellate court that said essentially, none of that matters, because the outcome probably wouldn't have changed. So here's my question for you. Do you think Heath Bell received a fair trial? Drop your answer in the comments. I genuinely read every single one, and I want to know what you think, especially if you think the legal system handled this the right way. I want to hear that perspective too. Don't just watch. Tell me what you see. Here is the thing that makes this case linger. The appellate court wasn't wrong on the law. Under Strickland, you don't just need to show that your lawyer made a mistake. You need to show that the mistake changed the result. And given that the trial judge had explicitly stated, multiple times, on the record, that he found Chamere Talley's statement to be given under trustworthy circumstances, the court found it nearly impossible to conclude that a 803/26 hearing would have ended differently. But here's what that conclusion requires you to accept. It requires you to accept that a statement obtained from a woman who was handcuffed, threatened, denied legal counsel, and subjected to prolonged psychological pressure, a statement she repudiated within weeks of signing it, repudiated again at a preliminary hearing, and repudiated again at trial, was legitimately trustworthy. It requires you to accept that the trial judge's credibility determination, made after watching Chamere Talley try to explain her recantation on the stand, was sound. And it requires you to accept that because everyone in that courtroom, prosecution, defense, and judge, collectively decided to let that statement in without the procedural safeguard the law required, the man whose life depended on that safeguard has no remedy. The co-defendant, Nicholas Augustus, was acquitted. Heath Bell was convicted of first-degree premeditated murder and first-degree felony murder. He received an effective sentence of life imprisonment. The jury chose to believe a statement the woman who wrote it spent 2 years trying to erase. Heath Bell remains incarcerated. His post-conviction petition has been denied at every level. As of the appellate ruling filed in April 2026, there is no indication of any further avenue for appeal on the grounds he raised. Chamere Talley, as far as the public record shows, was never charged as a co-conspirator despite the prosecution's theory that she helped set up the victim. The co-defendant walked free. And somewhere in all of this, a man named Joe Howell, who drove a woman home on a cold February night, and then went to make a drug sale, is still dead. His family still lost him. His story, the one that started all of this, is the one that gets the least amount of time in the appellate record. What this case forces us to confront is uncomfortable. The legal system has rules designed to protect people from exactly the kind of coerced evidence that appeared in this trial. When those rules aren't followed, or when they're waived by the very attorney supposed to be protecting his client, the law's answer is it probably didn't matter anyway. Maybe that's justice. Maybe that's just law. Sometimes those two things are not the same. If this case left you with more questions than answers, that's because it should. These are the cases I come back to. Not the ones with clean verdicts and obvious villains. The ones where the system technically worked and something still feels broken. If you made it this far, you already know this channel isn't about shock value. It's about understanding how the legal system actually operates, the rules, the loopholes, the moments where human judgment determines whether someone spends their life in a prison cell. If that matters to you, please like this video, it genuinely helps more people find this content. Subscribe if you haven't already. And share this one with someone who thinks the courtroom is always a place where truth wins. The next case I'm covering is something you won't want to miss. I'll see you there.